The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to this month's webinar on how to prevent race discrimination in the workplace. This free webinar is available exclusively for our customers enrolled in our subscription services. I'm Leon Frierson, the Publications Coordinator for Personnel Concepts, and I'm joined by my co-moderator, Karen Jonas, who serves as our Regulatory Monitoring Manager.
Hi, everyone. Thank you for joining us today. Our guest speaker is Christopher Ray, a Boston-based attorney licensed in Massachusetts and New Hampshire. Mr. Ray began his career as an in-house counsel for a large Denver-based technology company, working mainly on employment matters, data privacy issues, and contract matters. Since going into private practice, he has served on both the employer and employee sides of litigation matters, including litigation before the EEOC. He also provides regulatory compliance guidance for businesses in high-risk verticals such as cryptocurrency and the legal adult use cannabis industry. In partnership with a PHR certified HR professional, he also provides compliance training, ERISA plan design consultation, risk management, and employment law guidance to employers not currently in active litigation. He received his JD from the Suffolk University Law School, graduating with distinction in an elective concentration in labor and employment law. Thank you, Christopher, for joining us today.
Thanks for having me, Karen, and thanks to Personnel Concepts and to everyone in the audience who's joining us today. I'm looking forward to talking about today's topic of preventing race discrimination in the workplace. I think recent current events have demonstrated just how important it is for businesses to be mindful of both their reputations and of their compliance with anti-discrimination laws, and also to make sure that they've trained their workforces on treating people kindly and with respect without regard to race or other protected characteristics.
Definitely. We are looking forward to discussing it with you. Today's agenda focuses on preventing race discrimination. We will discuss the laws that address workplace discrimination and talk about how certain workplace procedures and policies can be discriminatory, even where they aren't meant to be. We will then examine different facets of discrimination, such as equal access to jobs, harassment, symptoms of discrimination, and a topic that can be especially scary for employers, vicarious liability or being responsible for the actions of managers and supervisors. Next, we will look at ways that employers can prevent discrimination, such as training and workplace policies. And we will also talk about what employers should do when they become aware that discrimination has occurred. Finally, we will offer tips for employers in order to help prevent and address race discrimination. Now, here's our first poll question of today's webinar. So get ready to answer by selecting one answer from the choices on your screen. We'd like to know how many employees you have on payroll. This information actually helps us determine which state laws specifically impact you and will help us in the creation of future webinars. I'll give everyone just a couple more seconds to answer. All right. So it looks like, thank you.
Thank you to everyone who answered today's poll. It looks like most of our employers, supervisors, managers, office managers, and HR personnel participating today fall into the 50+ range. So the format for today's webinar features are a series of questions that Karen and I will be asking to Christopher regarding preventing race discrimination in the workplace. Before we begin, I want to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also pose questions in the question window. Most questions will be saved for the end of today's session, but those that are relevant to the subtopic being discussed will be posed where appropriate. At the end of the session, you'll have an opportunity to use the Raise Hand feature in GoToWebinar to pose a question directly to our guest speaker. Now, we recognize that race discrimination is a sensitive and controversial topic for many Americans. All of our presenters today, myself included, will make every effort to avoid using any insensitive language or stating any personal opinions about the subject matter. We also respectfully ask that you use similar discretion if you are given an opportunity to pose a question to our guest speaker. Now, with that said, let's get started with today's presentation. Karen?
Thanks, Leon. Christopher, race discrimination, especially as it pertains to businesses open to the public, has been in the news quite a lot lately. Is this still a prominent issue in today's workplace?
Unfortunately, it is, Karen. So as you can see by the data that we've put up on the slide here, racial discrimination matters continue to be one of the most common employment-related causes of action that we see in America. At about 32,000 complaints received per year on average, race discrimination charges make up almost a third of all of the discrimination-based complaints that the Equal Opportunity Commission, or the EEOC, receives each year. So, in 2016 alone, EEOC complaints based on racial discrimination accounted for over $110 million in employer payouts. And this doesn't even begin to count the cost of the damages lost through private lawsuits, reputational harms to businesses, and of course, it doesn't include the lost wages and work opportunities for the victims of discrimination. The good news, though, is that immunizing your business against these kinds of claims is largely a matter of training, good policy, and common sense preventative measures.
And Christopher, are there specific laws that protect individuals against race discrimination in the workplace?
There are, Leon. So in this talk, we're mostly going to be addressing the federal laws that are relevant in this area, but everyone should be aware that there are likely state or possibly even town or municipality level rules that will slightly vary some of the procedures by which these laws are used. They may vary damages amounts or which businesses they apply to, but we'll mostly be focusing on the federal laws. The most important of which is Title VII of the Civil Rights Act of 1964. We usually just call it Title VII. It's the primary source of federal law which addresses race discrimination in the workplace. It creates most of the relevant causes of action in this area. There's a related law, 42 U.S.C. 1983, which we usually just call Section 1983. It works in tandem with Title VII to allow plaintiffs to recover money damages for violations of Title VII, as Title VII by itself only allows for injunctive relief, which is basically when a court orders you to do something as opposed to ordering you to pay money. So under Title VII, I'll just read from the statute really quick. It shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin, or to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. So I sort of leaned on some of the words there, like any employment action. The language of Title VII is deliberately very broad. As we'll see later in this talk, it even covers employment actions before the point of hiring, like recruiting. It covers all aspects of the employment relationship, from hiring and firing, down through rates of pay, hours worked, working conditions, benefits, vacation time, even job titles and dress codes.
Thank you for that, Christopher. Are there also laws that protect a person that has reported acts of race discrimination?
Yes, so while Title VII focuses on prohibited conduct as it pertains to discrimination based on race, there are laws like the Lilly Ledbetter Fair Pay Act and the Rehabilitation Act of 1973, which prohibit discrimination based on an individual's past history of complaining about discrimination. So, if an employee makes a complaint internally or to the EEOC or to a court, these laws prevent an employer from making future employment decisions based on having made that complaint. And this continues to be true whether or not the complaint was found to be meritorious or not, whether or not the employee was successful with that complaint or with that lawsuit. This even applies to complaints of discrimination that an employee has made in past jobs. So if you as the employer or a recruiter discover that a job candidate or an employee has a history of filing such complaints even against past employers, you may not base any of your employment decisions on that information. These laws are designed to prevent retaliation against employees for exercising their rights.
And do these federal laws apply to all employers? And what about state laws? Are employers required to follow those as well?
Great question, Leon. So discrimination is illegal everywhere in the United States. That includes territories, Puerto Rico, Guam, everywhere in the United States. Title VII specifically covers all employers in the United States with more than 15 employees. I think by our numbers, that probably represents about 70 to 80% of the audience. But everybody should be aware that one of the areas of discrimination law that is heavily affected by state law and local law is that state laws will often decrease that threshold or that floor for the number of employees that you need to have in order for these discrimination laws to apply to you. So if you're in a state like Colorado, for example, even having a single employee is enough for you to be covered under both Title VII and Colorado's applicable state equivalent. So you should always conduct yourself as if you are covered by Title VII. You almost certainly are, and hopefully your business aspires to grow to a size where it would be anyway. State and municipal governments themselves are regulated under a related law called Title II in discrimination matters. So now we talked a little bit about these state laws and their local laws, and just one more note on that is that no state government has the power to diminish the protections provided under Title VII. So state laws should be read just as carefully as the federal laws, but they're never going to relax the protections that are afforded to employees in the area of discrimination. They may vary the procedures for making a complaint. They may vary how damages are calculated. But they're never going to make it easier to discriminate against employees or potential employees. But that being said, Title VII is consistent nationwide, and it provides the bulk of the relevant law in race discrimination matters.
So here's another question for our audience. How many of you are open to the public? We'll give you a minute or so to answer, but the issue of race discrimination is especially important to employers who are open to the public, which we'll explain in just a moment. So it looks like some people are still responding. We'll leave this poll open for another few seconds here to find out. All right, I'm gonna close the poll. So it looks like many of you are open to the public. In fact, about 65% of you are open to the public, and this question is even more relevant to you. Christopher, what can you tell us about businesses that are open to the public? Do anti-discrimination laws protect customers as well as employees?
They do, yes. So I briefly mentioned Title II of the Civil Rights Act just now, and I'll read from another part of Title II, which says that, quote, all persons shall be entitled to the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of any place of public accommodation as defined in this section without discrimination on the ground of race, color, religion, or national origin. So as with Title VII, the wording here is very broad. It's meant to cover a substantial swath of the businesses in the U.S. And as with Title VII, there will be state and local laws that may fill in some of these gaps or the procedural functions of Title II. But as always, they are never going to relax the requirements. They will only make them tighter. So, that being said, a business does not have to engage in openly discriminatory conduct in order for Title II liability to arise. We are somewhat past the days of businesses that have, Irish need not apply or no Chinese welcome signs on the front of their businesses. Which obviously is a good thing, but you should be aware that you don't have to reach the level of an overt act like that for liability to accrue under Title II. The failure to offer equivalent levels of customer interaction or pricing, hours of access, areas of access, and customer service to any member of the public without regard for the categories of persons listed in Title II can constitute a compliance violation from a Title II perspective. As in the employment context, the key to Title II compliance is training. You especially want to be thinking about your so-called customer-facing employees. I'm thinking about salespeople, waiters and waitresses, customer service people, other customer-facing staff. Should be carefully instructed that they may not treat customers or the general public differently based on the apparent demographic features of that customer. So in addition to Title II of the Civil Rights Act, which prohibits discrimination in places of accommodation on the federal level, as I said before, individual states and even some individual counties and towns have their own laws that address these accommodations. The definition of what exactly constitutes a public accommodation may vary slightly from state to state, but you should assume that if your business is open to the public in the sense that a member of the public can walk in and shop for your goods or talk to someone on your staff, you qualify as covered under Title II. And if anybody here works for a state government or the federal government, the government itself is extended the same coverage and the same rules by Sections 501 and 504 of the Rehabilitation Act of 1973.
Thanks again, Christopher. Now, is it possible that employers have workplace policies that are discriminatory and they don't even know it?
Absolutely. So, as I had discussed, the era of workplace policies that are obviously racist in nature they're exceedingly rare. Few employers are so careless as to have written policies that plainly create a discriminatory treatment for certain employees or potential employees. The policy of no Irish need apply. Those things just don't exist anymore for the most part. We can call that kind of discrimination one large category of employment discrimination suits. We'll call those disparate treatment lawsuits. There's a whole nother category, which is the substantial bulk of litigation in this area that happens these days, which we'll call a disparate impact. So this refers to employment decisions that appear to be neutral on their face, but that ultimately have discriminatory consequences.
Thank you, Christopher. Could you give us an example of disparate impact?
Sure. So I'll just go to the case law here. So the first significant U.S. Supreme Court ruling on this point, the case that coined the term disparate impact and recognized it as a valid cause of action, is the Griggs versus the Duke Power Company case. So a quick factual background. In 1955, the Duke Power Company instituted a requirement that all but its lowest paid and most menial jobs required a high school diploma before you would even be considered as a job applicant, regardless of how difficult or complex that job actually was. So now, on its face, this policy, it might seem a little bit onerous. This case was from the 1970s when a high school diploma meant something different than it does today. But otherwise, it might seem like a reasonable policy. Certainly not a discriminatory one. It merely required that everybody, without regard for race or gender or anything, have a high school diploma. But in 1971, the Supreme Court decided that this policy violated Title VII, and its reasoning was this. Number one, the court found that the policy had the impact of excluding African Americans from jobs at Duke Power at a far higher rate than members of other races or other workforce participants. But number two, and just as importantly, the court found that the diploma policy was not reasonably job related, basically that it was too restrictive and unreasonably so. The court found that there was no particular reason that Duke should require some level of education for most employees, especially for the easiest or most menial or manual jobs, but not, for example, require advanced degrees for difficult or highly complex jobs. There was also no particular reason that things like equivalent work experience wouldn't qualify as a substitute for education. The essential thrust of the policy was that its function to exclude African Americans from the job applicant pool, working hand in hand with the fact that African Americans were far less likely to have a high school diploma in the workforce around the Duke Power Company. And so in making this ruling, this is something that we'll go into more detail about later, but the court did not run through a checklist of factors or a series of yes or no check boxes or anything like that. They looked at the totality of the circumstances. They looked at the whole picture that was going on here. So, for example, the court also noted that until 1954, the Duke Power Company had a policy which basically just said, no African Americans need apply. That the company had a troubling history of much more overt disparate treatment level of discrimination going on, and so they saw this policy as sort of a pretext for the old policies. So a finding of a hidden discriminatory motive like this, it's not required for liability on a disparate impact theory, but an EEOC examiner or a court investigating such a claim will often use any such history of bad behavior or concealment of improper motives to make its decision about policies with disparate impact.
So what if an employer wrote a policy that essentially ends up having a disparate impact, but that was not the intention of the employer, and there's a good reason for said policy?
Great question, Leon. So, not all policies with a disparate impact are unlawful under Title VII. The EEOC, in its materials on this matter, uses the example of imagine a hypothetical pizza delivery restaurant with a no beards policy. All of its employees must be clean shaven. So suppose that a plaintiff is able to demonstrate that this policy has the impact of disproportionately excluding Muslims or Sikhs or Orthodox Jews or African Americans who are more likely to have an inflammatory skin condition that's caused or irritated by shaving. The policy therefore has a discriminatory impact, even if it does not have a discriminatory intent. So if a plaintiff were able to establish that, the employer would then have the opportunity to rationalize the policy to the court as a neutral business decision. So if the employer were able to argue successfully that the policy serves, for example, to keep hair out of pizza, then the employer would likely prevail in that lawsuit. The employee would have the opportunity to show that the explanation was pretextual or faulty in some way, but the business will have the opportunity in any action under Title VII to explain its policies that are accused of being discriminatory. And so this shifting of the burden of proof, where the plaintiff comes to the court with a complaint, the business then has the opportunity to explain the policy, and then the employee has the chance to undermine that explanation, and the court makes a credibility call as the plaintiff and defendant. This shifting of the burden of proof is typical in discrimination lawsuits. That's the normal pattern in any such case. So your obvious practice tip here is that business decisions that are well supported with independent, objective business reasons are highly resilient to complaints about discrimination.
Christopher, one area of employment that you think about when discussing race discrimination is the hiring process. Could you talk a little bit about equal access to jobs?
Sure, Karen. So under Title VII, as I had said before, job relatedness or job actions is meant to be read very broadly. And under Title VII, recruitment is an employment decision. Recruitment practices that purposefully discriminate on the basis of race or that disproportionately impact access to jobs based on race without a legitimate business reasons are just as actionable under Title VII as discriminating against your actual current employees. And this also applies not only to actual hirers and recruiters, but to third parties like independent recruiters or staffing agencies and to businesses that do their own recruiting. So a classic example of a neutral sounding recruitment policy that often has a disparate impact is the practice of only hiring through word of mouth, only hiring based on the verbal recommendations by your current employees for specific people that they know are looking for a job. This is a policy that can be open to attack on Title VII grounds because people just tend to socialize with people who have similar backgrounds to them and come from similar circumstances. And so such a policy will often have a racially disparate impact without a legitimate business purpose. Title VII also provides that employers cannot use race as a screening criterion. We'll go into more detail about when you should or shouldn't collect demographic information when recruiting, but just note that Title VII does also specifically state that you cannot use race as a screening criterion. On the same lines, though, nebulous job requirements can be just as dangerous from a liability perspective. And I counsel my clients about this kind of thing pretty frequently. So imagine an employer who has a requirement that new employees be quote unquote trustworthy. This is a policy that may seem neutral or even reasonable on its face, but without a very clear definition for the hiring person about what is trustworthiness, you're essentially opening the door for the private biases of your recruiters or your hiring personnel to creep into your corporate culture. And so I strongly caution people that one of the most abundant sources of discrimination complaints against recruiting and hiring practices is based on these opportunities to let your employees make a gut call or to rely on their intuition. That only allows these personal biases to exert outsized influence on the culture and behavior of an entire company.
Thanks again, Christopher. I do have a live question too from Astrid. If you could throw this in with the next question, she asked, is asking, do you speak Spanish on a job posting discriminatory? And then what are some other examples of unlawful hiring practices that could be found as racially discriminatory?
That's a great question. Let me get to that first before I continue on to some of those other examples, because this is also something of a hot topic in modern day litigation over Title VII issues. So there is nothing specifically in Title VII that speaks to the language abilities of someone that you're hiring. That being said, though, a requirement that somebody, for example, either speak Spanish or speak English without an accent are opportunities for your hiring practices to be viewed as discriminatory. So if somebody looks at a job posting which requires that the speaker or that the applicant speak Spanish, this could be viewed as merely a pretext for discriminating against persons who are not of Latin American descent or otherwise do not have a national origin that is from a country where Spanish is the main language. So, as always, the strongest route that you can take is that if you are going to institute such a hiring policy, which is not independently unlawful on its own, that requirement should be clearly job related, and you should be able to back up your company's assertion that that requirement is job related. This will often take the form of, if you're hiring for a customer service job and you can show that 25% of your customer service calls are from a Spanish proficiency or Spanish only speakers, something like that would be a powerful tool in your arsenal for defending that policy against an accusation of bias. Great question, though. So other examples of potentially unlawful practices may include soliciting applications only from sources in which all or most potential workers are of the same race, requiring applicants to have a certain educational background that's not important for business needs, or unnecessarily testing applicants for knowledge or skills or abilities that are not important for their job performance.
Is there ever a circumstance in which it is acceptable for an employer to ask an applicant about their race?
Great question. So under Title VII, employers are allowed to collect information about race for purely demographic purposes only, basically for their internal, just good to know purposes only. There may be other circumstances. For example, if anyone in the audience works for a firm that does a lot of GSA work, or a lot of work with the federal government or the state government, sometimes a GSA contract or a state government contract will actually require you to make certain disclosures about the racial demographics of your workplace. In which case, you obviously, in a case like that, you do want to collect that information. The practical tip here that I give to most of my clients in these matters is just that if you are in a position where you feel it is either important or necessary or both to collect information about the racial demographics of your workforce, a good strategy is to have sort of a two-tiered hiring process where you may have an intake person or the person who actually receives the resume collect the demographic information that you solicit and then scrub that information before forwarding the resume on to the person who has the actual power to schedule an interview or bring someone in. So the EEOC's guidance, they suggest using separate forms or otherwise just keeping that information separate from the application to guard against discrimination and to ensure that the information is not used in pre-employment questioning as the basis for hiring decisions.
Thanks again, Christopher. Now, in many of the cases that the EEOC responds to regarding race, the issue isn't discrimination, but rather racial harassment. Can you discuss what constitutes racial harassment?
Great question, Leon. So courts have long recognized that Title VII creates an anti-harassment cause of action that's very similar in nature to sexual harassment. It's also known as hostile work environment theory. If anyone in the audience has ever been trained or had to deal with an issue like this, the hostile work environment theory is virtually identical from a legal perspective between sexual harassment and race-based harassment. So harassment in the forms of racist comments, off-color or racially charged humor, or that kind of behavior from coworkers is either highly prevalent to the point that the plaintiff's job basically requires them to be exposed to it, or is one-off or transitory, but it's so extreme that any reasonable person would find the behavior shocking. Then the employee would have a viable cause of action against the employer. So in their materials on this point, the EEOC writes that they will look at several different factors when evaluating a claim of racial harassment, which again, very similar to the factors that are at play in a sexual harassment case. They will look at the frequency of the unwelcome harassment. They'll look at the severity of the harassment. They'll look at whether or not there was a physical threat or intimidation involved or merely an offensive utterance. They will look at the actual effect on the victim's psychological well-being. And they will look at whether the harasser was a superior within the organization to the person being harassed. So now, this is not a complete list. As with any Title VII cause of action, the court or the examiner will be looking at the entire circumstances. There is no one bright line rule for determining whether or not a policy or an employment decision or a pattern of behavior is discriminatory.
Thank you, Christopher. We're going to ask another question of our audience, and this time we're looking for you to use the raise hand feature, which is the little yellow hand located on the sidebar of the control panel. So here's the question. How many of you have witnessed race discrimination or are concerned about race discrimination in the workplace? Hit the raise hand feature if you're concerned. It's that little yellow icon. Looks like we're seeing a bunch of hands here. Clearly this is an issue for many of you. And your answers will actually tie into the next question for Christopher. So thank you all for raising your hands. Is there anything that employers can watch for that can alert them that race discrimination is occurring in their workplace?
Sure. So in some situations, identifying workplace discrimination can be difficult. Discrimination in interview questions or in work assignments or meetings with superiors, they may happen or continue to happen behind closed doors, especially if managers and staff aren't aware of the appropriate policies or that right avenues to report discrimination issues. It may manifest, for example, as high turnover among certain demographics of your workplace if people are unhappy with the work environment. This would often be the result of consistent demeaning or harsh communications from managers or coworkers or other frequent offensive comments or jokes. So as a reminder, it didn't help the Duke Power Company's case that it had a long history of disturbing racial bias, even though its past discrimination was not illegal per se at the time that it happened. Isolated or borderline incidents that do not by themselves amount to a lawsuit, but they're all taken together portray the employer in a negative light can make all the difference in a discrimination lawsuit. So if an EEOC investigator or a court is investigating your workplace and they find that there have been these, I don't want to say minor, but at least infrequent and less severe incidents in the workplace that may not have risen to the level of an actual lawsuit or a formal complaint, these will often be seen as critical factors in the investigators or the courts making a credibility call as to an employer and an employee who may otherwise only have each other's words to back up their own case. They will therefore look to the totality of the circumstances in weighing the relative likelihood that one employee or the other accurately describes the workplace. So when they're conducting these investigations, the EEOC has a lot of tools in its arsenal for these investigations. They'll use their tools to conduct interviews with employees. They'll review emails or other written exchanges, including sometimes text messages. One tool that they're fond of is running blind tests on an employer. So, for example, having two investigators of different races apply for the same job using otherwise identical resumes. So in many cases, investigators will also use complex statistical data to look for patterns. They may, for example, compare the racial demographics of your workplace against the racial demographics of the workforce around you from which you're hiring. They may also use similar mathematical tools to contrast past employees by measures like tenure, starting salary, when they get raises, and their turnover rate. So investigators have many tools at their disposal that, if used properly, are generally admissible in EEOC hearings and court cases to evaluate the relative strength of competing claims.
Thanks, Chris. So what happens when the employer does everything they can to prevent racial discrimination, but then there is an incident in the workplace in which another employee is accused of discrimination or harassment? Is the employer still liable in that case?
Right. So unfortunately, employers are pretty much always liable for the conduct of their employees in the workplace, which includes, at job sites, on delivery runs, or otherwise while on the clock. Lawsuits are waged against companies, but they arise from the bad conduct of individuals. Oftentimes, the degree to which an employer is penalized for engaging in such behavior will be determined in part by the employer's knowledge of their employees' conduct and the steps that they took to remedy that conduct. So, for example, I practice in Massachusetts, where if an EEOC investigator or a court in a lawsuit of this kind does an investigation and finds that the employer became aware of such actions and took prompt and decisive corrective action, that can somewhat be in their favor. But if they find that the employer was deaf to frequent complaints, courts will actually be under a legal duty to multiply the employee's damages by 3. So these issues of knowledge and how you respond to and how you remedy behavior of which you become aware can be extremely important. You should always be an active and conscientious monitor of the conduct of your employees towards each other and towards your customers. So, for example, employer policies and handbooks should be unambiguous about the consequences of engaging in discriminatory behavior or using racial humor, that kind of thing in the workplace. And an employer who uncovers evidence of such behavior should take prompt and decisive corrective action.
Here is one last poll question for our audience. Get ready to answer the poll question. How many of you have an anti-discrimination and/or an anti-harassment policy in effect at your workplace? We have 4 options here for having either both a policy for both discrimination and harassment, one for just harassment, one for just discrimination, or you don't have a policy in effect. So I'll give you all a minute to answer. So once again, do you have an anti-discrimination or an anti-harassment policy in effect at your workplace? All right. So it looks like most of you have a policy for both anti-discrimination and anti-harassment. So for those of you who don't yet have a policy in effect, which is about 12%, you'll want to pay close attention to this next question. Christopher, you mentioned employer policies. What do you suggest that employers include in anti-discrimination and anti-harassment policies?
Great question, Karen. So, such policies, they should be, tailored to your workplace and the kind of business that you do. They should be conscientious of your own circumstances. But at the very least, all such policies should create a zero tolerance policy for any form of racial discrimination. An employee who engages in such behavior, whether they're making employment decisions or in any other interaction with their coworkers, they jeopardize the entire company. And so prompt and decisive corrective action to the point of termination really is the only appropriate response to a credible complaint of this kind of behavior. Furthermore, such policies, they should be clear, They should be straightforward, and they should be thorough. They should provide clear examples of what constitutes discriminatory behavior, and they should carefully describe preventative measures and a zero tolerance policy, and they should also clearly explain the procedure for how complaints are handled. The policies should specify who the points of contact are for making such complaints, and you should have multiple points of contact for the simple reason that, what if you designate a single person as your contact person for such complaints, and somebody wants to make a complaint about that person? Trying to avoid that circumstance from arising is alone enough of a reason to have multiple people who receive, such complaints. So once you have that procedure in place, your company should enforce it consistently, and they should have a policy that is clear and that is consistently applied for investigating and resolving such complaints. As I mentioned earlier, if you are dealing with the EEOC or a court in one of these matters, they will often look to what your internal process is for handling your complaints. Number one, because state law will often require that an employee use the company's internal policy before they go to the EEOC. And so if an employee does not go through this policy or through your internal channels, but the EEOC then finds that the reason that your internal procedure was not used is because it's a sham, or it's merely pretextual, or because you don't really enforce the policy, you don't really follow your own procedures, then the EEOC will generally give a pass to the plaintiff on not following your procedures if they think that those procedures are merely a sham or a pretext in the first place. And so finally, your policy must contain, it absolutely must contain, a no retaliation clause. This serves two different purposes. One purpose being that you just clearly explain what the law explains, which is that retaliation against somebody for making one of these complaints, even a non-meritorious complaint, is forbidden. But you also give your employees that level of assurance that they can safely use your internal policy because you have promised to them that you are not going to retaliate against them for using that policy. And so, once that policy is in place, your files and your reports about these claims should be kept separate, and they should be kept secure from other personnel files to prevent accidental disclosure to the wrong person, and oftentimes because your local and state level record-keeping laws will require such separation. One more note on these procedures in place is that it's not only important from the perspective of showing your own good faith efforts to both prevent and to resolve issues of discrimination in the workplace. You also want to be educating your employees about what is and what is not acceptable behavior. You should at least be providing regular training to the personnel who have any level of employment decision-making authority on the best practices in preventing discriminatory behavior.
Thanks again, Chris. So moving forward, what do you recommend employers do if they receive a complaint of racial discrimination or harassment?
So investigating complaints of discrimination or harassment is complex. Management and HR professionals are often quick to act either decisively one way or the other upon receiving a complaint, when really the right thing to do is to be conscientious and objective and purposeful in the design of your investigation. So if a complaint is received, you should go through a certain workflow for making sure that the investigation is carried out properly. You should have these procedures already in place before the investigation begins. You should decide beforehand who does the investigation. You should decide beforehand what is the extent of that person's authority to investigate. Can they read emails? Can they read text messages? You should decide what constitutes relevant evidence, including by way of interviews, and in what form should the final opinion be rendered, and what decisions will be made based on that opinion. The person who made the complaint should be treated with respect and with compassion. And only under the most gratuitous circumstances should that person be punished or terminated or otherwise treated adversely during the pendency of the investigation. The anti-retaliation provisions of Title VII and Title II are very clear and they're quite unambiguous, and you really do not want to expose yourself to liability on a retaliation theory by taking any adverse action against the person who made the complaint in any but the most extreme of circumstances. So anyway, your investigators should be empowered to conduct interviews. They should be empowered to read emails sent from company email accounts, and they should otherwise be empowered to do anything that's reasonably necessary to come up with an accurate conclusion. Your investigators should also be carefully trained to be discreet and to be objective and to be thorough. That all being said, always cooperate with a government agency. But you should be focused on building an inclusive workplace in the first place to avoid getting there at all. So these investigations should also be carefully documented as they proceed to undermine any later claims that the investigation was made not in good faith or was not complete or that the process was a sham. Reports should be labeled as to the matter discussed in those reports, who was being interviewed in those reports, and those reports should be marked as confidential and should be shared only with a government investigator or with someone who is on a need-to-know basis for the contents of those reports. They should provide as thorough and objective an explanation for any final determination as possible. As with every Title VII action that we've discussed so far, a thorough, objective explanation and objective rationale is the key to protecting your interests in any legal actions.
Christopher, isn't it the case that sometimes people fail to report discrimination and harassment because they fear being retaliated against?
Yes, that unfortunately often is the case. And as I mentioned earlier, this can actually sometimes be fatal to a plaintiff's complaint because some state laws will require that an employee go through an internal process. Then the employee only having the opportunity to save their case if they can show that your process was a sham or pretext. So it's important that you communicate to your employees that they do have the right to be free from retaliation for their complaints to the EEOC or their internal complaints or their court filings or for testifying or assisting or otherwise participating in an agency proceeding or somebody else's complaint. This is true even if the complaint is ultimately found to be without merit. A zero tolerance policy for retaliation for making complaints should be as part and parcel with your zero tolerance policy for discrimination itself.
Thanks again for that information, Christopher. And in closing, do you have any final tips for employers?
Sure. So let me just go through sort of my 5 practice tips for everyone in the audience. These is advice I would give to most of my clients anyway. So first of all, when in doubt, consult the EEOC. The EEOC's guidance on these matters is pretty good, actually. It's they've written their guidance on most Title VII matters, not with lawyers as the intended audience, but for HR personnel, for managers, for business owners and entrepreneurs. You should always talk with qualified local counsel or your in-house counsel whenever an issue either arises or if you're looking to do compliance or preventative work. But when in doubt, the EEOC is actually a great place to go for resources on this kind of thing. Many state-level EEOC offices will also provide confidential or anonymous inquiry lines, either by phone or by email. Some EEOC offices will accept inquiries by way of a hypothetical so that you can pose questions directly to the EEOC without having to worry that they're going to trace that complaint back to an actual incident that may have occurred or that may occur at your workplace. Number 2, this is a practical tip, especially for people who make hiring decisions. Don't expose yourself to information that you don't want to know. I use the example of businesses that may be required or that otherwise choose to collect demographic information about job applicants or their actual workforces. In that example, my guidance typically is to have a 2-layered or a multi-layered intake process that allows the person who collects and compiles that demographic data to scrub that identifying data from whatever resume or CV or recommendation ultimately gets passed on to whoever books the interviews or sets the appointments or makes the hiring decision, for the express reason that nobody can accuse you of discriminating based on information that you don't know, right? And that you may be in a position where you may be curious on a personal level about, say, someone's religious practices. But unfortunately, it's oftentimes just better for you not to solicit or to review information that you don't have a bona fide business purpose for having. This can save you a tremendous amount of liability for, again, the simple reason that if you don't know it, it's really hard to see how you could discriminate based on it. So, on the same lines, I would also say next to give your personnel with the authority to make employment decisions objective metrics for making those decisions. It being in your best interest to minimize the amount of unilateral discretion that such personnel have in making employment decisions. We had used the example earlier of a requirement that a job applicant be quote unquote trustworthy. You are, by having nebulous job requirements either at the hiring point or at job evaluations or at any point where information or data is used to make an employment decision, the more objective that data is, the better. I like to think of the example of the inside salesperson as, in theory, this is the most discrimination-proof job title, right? Because for an inside salesperson, there's no criteria for your performance other than that if you hit this sales number this month, you keep your seat. If you don't, you go home, and that's all there is to it. There is very little room in the inside salesperson's workflow for anyone's personal biases to impact that person's career with the company. And so it can be really helpful if you try to extend these objective metrics to other job titles. For example, if you have an HR person and say, your job this year or your goal this year is to reduce turnover by 15%, or you can tell somebody who's on customer service, your performance will be based on how many 5-star reviews we get on Yelp this month or this year or something that is an objective basis for making your employment decisions. Number one, these will typically just make you a better business because you will have consistent KPIs for success for the people that work for you. But number two, as throughout this talk, we've been talking about how objective business reasons for employment decisions are your sword and your shield against discrimination complaints. If you have objective metrics for those decisions, you'll have a much easier time justifying policies that may unintentionally have a disparate impact on certain people. So, moving right along, fourth, I would say you should invest in making your workforce in an inclusive place. Time and resources spent on training, documentation, common sense policy making, internal rules and procedures, they can save you from huge problems down the road. Labor and employment matters and HR matters. This really is an area where a minute amount of prevention is worth an enormous amount of cure. The amount of preventative work that you need to make your workforce feel safe and welcoming to your employees is much smaller than the headache and the tremendous harms that there can be to your morale, to your pocketbook, and to your public reputation with your customers in a lawsuit or an EEOC complaint. So I do lean heavily on you guys in the audience that you should be using services like those offered by Personnel Concepts or others to make sure that you have built a workplace that is inclusive and friendly, because it's much easier than fighting an EEOC complaint. And finally, I like to say that general counsel and human resource leaders should work together closely on any of these matters. I come from the world of in-house counsel, and I can say that working in close partnership with human resources directors made a huge difference in terms of doing our jobs well. For those of you in the audience who are HR professionals or in-house counsel, you probably had the phenomenon of not really knowing for sure if what you're looking at is an HR matter or an employment law matter. They're so interweaved sometimes, and the lines are so blurry that it oftentimes just makes sense to have your general counsel and your HR people in on the same meetings, consulting with each other on important decisions, or even on routine decisions if you have specific concerns. So, my personal experience, I strongly encourage you, get your general counsel and your VP of HR in a room together. Just have them check in every now and then. This, once again, is one of those areas where a very small amount of prevention could make all the difference. The line between legal issues and human resources often just being so blurry.
Thank you, Christopher, for reviewing this information with us. Before we end today's session, let's take a moment to answer some questions from our audience that were submitted during the presentation. Leon will ask the questions on behalf of our attendees.
All right. Well, thank you all for participating and submitting questions first off. I do want to answer a question for Francine and others that have similar questions. If the slides will be going out to our audience members. And yes, we'll be sending out the presentation you see today to our registrants in the next couple days coming after the presentation. So you can expect that in your inboxes. I do have a question here from Lauren. She asks, are there protections for retaliation still applicable in an at-will state? For example, if someone reports someone that gets fired or reprimanded for causing trouble or not being a culture fit, would they be protected by anti-retaliation if they are in an at-will state?
Lauren, that's a great question. So 49 out of the 50 states in America are so-called at-will states, meaning just very, very quickly that you can be hired or fired for pretty much no reason apart from a discriminatory reason. So one thing that we see in a lot of EEOC complaints and lawsuits is that terms like you use, like, not a good culture fit or not a team player, are often viewed as mere pretexts or as excuses for what really is a creeping bias. For example, refusing to participate in racially charged humor, or for being thought of as, the person in the workplace who just isn't as much fun as everybody else because they're uncomfortable with inappropriate behavior. So yes, even in an at-will state, which is most states, or in an at-will context, the anti-discrimination and anti-retaliation rules will apply to everyone. And one further note of caution to just extend the question slightly is that if you use contracts with your employees, whether they create a formal contractual arrangement or merely as a policy, you cannot have a policy in place that forbids your employees from making a complaint either internally or to the state or federal government. Such a policy, if made, would be found to be unenforceable and would typically be viewed as a factor in trying to chill the otherwise valid complaints of your employees. So yes, even in an at-will state, these protections will continue to apply, and trying to restrict these rights beyond merely requiring that your employees use your internal process before going to the EEOC generally will not be of much help to you in a lawsuit.
Thanks, Chris. And Isabel, I can answer your question. Yeah, we do have other scheduled seminars. They happen about bi-monthly, so just stay tuned and stay close to your email. As long as you're a subscriber, you will get notified of our upcoming webinars. I do have a question also from Scarlett. This will likely be our last question. She would like to send a harassment questionnaire/survey to her employees. Do you advise caution against implementing a survey of that nature?
That's a great question, Scarlett. I think that surveys like that are actually, if done properly and carefully and for well-intentioned reasons, are actually a really good idea. From the perspective of a litigator, they give you the imprimatur of trying to head off problems before they occur. So from a purely litigation standpoint, collecting such information can actually be really helpful from that perspective. They show that you are taking efforts to understand your workplace. Number two, just being because if the survey yields troubling information, you can act on it promptly, whether that's in the form of a complaint or anything like that on your survey. They can actually be helpful in rooting out problems that you may otherwise not know about until they erupt into litigation. That being said, obviously, when you give out these surveys, you want to anonymize them. You don't want to earmark anybody's surveys, obviously, and make sure that when collected, they're used for internal purposes only. And the surveys, any text on that survey should clearly explain that the survey is anonymous. And they will not be used for any purpose other than for possibly internal trainings or compliance for policymaking, and that nobody's survey answers will be used against them or will be treated as a formal complaint, for example.
Thanks again, Chris. I do want to point out we had a pretty specific question from Joseph and others, Renee as well. And so unfortunately we have run out of time, and all those unanswered questions will be forwarded to Christopher via email, and his responses will be sent out to all the attendees in the coming days. So we'll make sure that you get an answer to that question, Joseph. And thanks to everyone who did submit questions about today's topic, and thanks to Christopher for taking the time to answer them. Karen?
We enjoy hosting webinars for our valued customers, and as such would really appreciate your feedback. Please stick around a couple of minutes as a brief survey will open up for you to rate what you saw and heard today. This concludes today's webinar. Thank you for attending today's presentation. We hope you found this information useful in understanding and preventing racial discrimination in the workplace. Thanks again to Christopher for being our guest panelist. We look forward to continuing to work with Christopher on future presentations. To all of our attendees, thank you for choosing Personnel Concepts as your provider of workplace compliance solutions. Have a good afternoon, everyone.